The power structure, the authority that the Canadian government as a structured body is putting forward. It's an illusion. Yes, if you disobey this structure, it will try to punish you by the domestic laws that it created. But when you hold this structure up to the international law, when you hold this government structure up to peremptory norms, to recognition of being, then this structure by default has collapsed its authority for not building itself upon the requirements. When you hold it up to the obligations it has under peremptory norms, it is completely failing and therefore has abandoned its authority, has abandoned its recognition. The authority Canada projects is an illusion. Domestically, it can punish us, but judged by peremptory international norms and the recognition of being, that authority collapses. The state has failed its obligations and abandoned true legitimacy. The authority the Canadian state asserts through domestic statutory structures is illusory. While those structures may exert coercive force, they must be measured against binding international obligations, including jus cogens, and the covenant rights that recognize the dignity and rights of the conscious being. Measured by those peremptory norms, the state's statutory framework fails to satisfy its obligations. Having structured governance in a way that denies recognition of the being it governs, the state has thereby forfeited the legitimacy it claims. They call it authority, a structure of rules and punishments. But hold it up to the international standard of human dignity and peremptory law, and the facade falls away. When a state refuses recognition of the being it governs, it abandons its claim to authority. The authority the Canadian state asserts through domestic statutory structures is illusory. Coercive power may be exercised through such structures, but legitimacy is tested not by internal enactment, but by peremptory international norms. Where those norms, such as the inherent recognition of the human being under Article 16 of the ICCPR, are denied, the statutory claim of authority collapses, leaving only de facto control without lawful foundation. The authority the Canadian state asserts through domestic statutory structures is illusory. A government that refuses to build itself on recognition of being and universal norms does not govern by right, but by narrative and fear. Strip away the illusion, and what remains is not authority, but an abandoned claim to legitimacy. The authority Canada asserts through its laws is an illusion. Yes, it can punish, but measure it against peremptory norms, against the recognition of the human being, and the facade falls. What it holds is power, not lawful authority. The statutory claim of authority collapses, leaving only de facto control without lawful foundation. A government that refuses to build itself upon the recognition of being and the peremptory norms of international law does not govern by right, but by narrative and coercion. When the illusion is stripped away, what remains is not authority, but an abandoned claim to legitimacy. The statutory claim of authority collapses, exposing only de facto control without foundation in law. When a government refuses to ground itself in the recognition of being and the universal order, it rules not by right, but by narrative and fear. Strip away the facade, and what remains is no longer authority. It is an abandoned shadow of legitimacy. The statutory claim of authority collapses, leaving only de facto control without lawful foundation. Under Article 16 of the International Covenant on Civil and Political Rights, every human being has the absolute right to recognition as a conscious being before the law, and under Article 18, the non-derogable right to freedom of thought, conscience, and belief. These rights are jus cogens norms, entrenched under Article 53 of the Vienna Convention on the Law of Treaties, and no domestic statute may derogate from them. The Supreme Court of Canada has affirmed that laws devoid of legitimate purpose cannot command obedience. R.V. Big M Drug Mart Ltd. It has also recognized that administrative and executive actors must justify their conduct in law, just as citizens must. Zingre v. the Queen, and that international customary law forbids a state from invoking its internal law to excuse non-compliance with international obligations. Further, the court has distinguished natural persons from artificial creatures of statute, affirming that individuals, by operation of law alone, enjoy full legal capacity independent of state recognition, owing no duty to the state beyond the protection of life and property. Thomson Newspapers Ltd v. Canada. The court has also held that Canada's international human rights obligations are a vital indicia of charter meaning, requiring that the charter be presumed to provide protection at least as great as that afforded by international human rights instruments. DeVito v. Canada. Public safety and emergency preparedness. In addition, it has confirmed that statutes should, where possible, be interpreted consistently with Canada's international treaty obligations and principles of international law. Nemeth v. Canada. A government that refuses to build itself upon recognition of being and peremptory norms does not govern by right, but by narrative and coercion. Stripped of conformity to these obligations, what remains is not lawful authority, but an abandoned claim to legitimacy. R.V. Big M Drug Mart Ltd, 1985. Principle: a law without a legitimate purpose cannot command obedience. The Charter strips away laws whose objectives violate fundamental rights. Interlock. This establishes the test of legitimacy. It means state authority is not absolute. It is conditional upon serving a lawful, rights-respecting purpose. Zingre v. the Queen, 1981. Principle: government agencies and tribunals must justify their actions in law, just as individuals must. International customary law prohibits a state from invoking internal law or from using domestic law to excuse failure to meet international obligations to peremptory norms. The government cannot claim a domestic law if that law violates our being as recognized under the universal order, under the peremptory norms. Interlock. Where Big M sets the legitimacy test, Zingre enforces accountability symmetry. The state is held to the same standard as the citizen. This collapses the facade that government can make it lawful by fiat. It aligns Canada's obligations directly with international law. Thomson Newspapers Ltd v. Canada, 1990. Principle: natural persons have full legal capacity by operation of law alone, while artificial statutory persons exist only by state grant. The individual owes no duty to the state beyond protection of life and property. Our beings were not born with duties and obligations flowing from statutory law. All these implicit impositions placed upon us by the government is a direct violation of our being. Interlock. Big M and Zingre deal with limits on authority. Thomson addresses who the law actually recognizes. It shows that being precedes statute, that natural persons exist with rights inherent in law, not as creations of government. This aligns directly with ICCPR Article 16. At its core, Thomson Newspapers makes a foundational distinction between two categories of legal subjects: natural persons. They enjoy full legal capacity by the operation of law alone. This means their recognition is not contingent upon government approval, legislative enactment, or administrative acknowledgement. Their rights exist independently, flowing from the law of the land, long before the formal establishment of the state. The only duty owed by such individuals to the state is the minimal obligation tied to the state's legitimate function: the protection of life and property. Artificial statutory persons, corporations, agencies, etc. They are creatures of the state. Their existence, powers, and civil rights depend entirely on statutory grant. Unlike natural persons, they have no inherent recognition. Their capacity is derivative and revocable. Why? This matters. Being precedes statute. Thomson establishes that the natural person's legal recognition is ontological, not conditional. A human being does not become a legal person by government fiat. They are recognized as such inherently, consistent with ICCPR Article 16. Government cannot invert recognition. By trying to force individuals into statutory personhood categories, citizen, taxpayer, licensee, etc., government oversteps its lawful foundation. These categories are administrative conveniences, not the basis of being. When statutory constructs are elevated above natural recognition, the order of law is inverted. Rule of law versus rule by statute. The judgment reinforces the classical rule of law principle. The state exists to safeguard pre-existing rights, not to create or define them. In effect, Thomson echoes Blackstone's view that the law does not bestow rights, but recognizes and protects them. Direct tie to peremptory norms. Since natural personhood is recognized without condition, this aligns directly with Just Kogan's and ICCPR Article 16. No derogation is possible because recognition of being is not a legislative choice, but a universal requirement. In the interlocking structure, where Big M establishes that laws without legitimacy collapse, Zingre ensures the state cannot justify itself with internal law. Thomson answers the question, whom does the law recognize? Answer, it recognizes the natural person inherently. Artificial persons exist only at the grace of statute. This turns the Canadian government's authority claims inside out. It is the state that depends on statute for its recognition, not the individual. DeVito v. Canada, 2013. Principle: international human rights obligations inform the scope of charter rights. The charter must be presumed to provide protection, at least as strong as international covenants. Interlock. This bridges domestic constitutional law with international obligations. Where Thomson shows that rights exist apart from statute, DeVito ensures that charter interpretation cannot fall below ICCPR standards. This means Canadian courts are bound to interpret rights in line with peremptory norms. Nemeth v. Canada, 2010. Principle: statutes should be read, where possible, to be consistent with international treaty obligations and principles of international law. Interlock. This closes the gap that governments often exploit. Even where Parliament enacts statutes, those statutes must be harmonized with international obligations. In other words, international law acts as the measuring stick against which statutes must be interpreted. How they form the rule of law. Big M. Authority fails when its purpose is illegitimate. Zingre. Government must justify its acts in law. Cannot hide behind internal statutes. Thomson. Recognition of natural persons is inherent, not statutory. DeVito. Charter must align with international human rights standards. Nemeth. Statutes must be read consistently with international law. Together, they make clear that authority is not presumed. It is conditional on compliance with higher law. They align the Charter and statutes with international obligations as the baseline. They enshrine that individual recognition and capacity exist apart from statute, consistent with peremptory norms. They collapse the Canadian state's claim to lawful authority when it acts contrary to international human rights law, leaving only de facto power without legitimacy. In short, Big M =, legitimacy test. Zingre =, accountability, symmetry. Thomson =, natural recognition. DeVito =, charter treaty, alignment. Nemeth =, statute-treaty alignment. That's the interlocking structure of the true rule of law, one that binds Canada to peremptory norms, rather than allowing government to define its own authority. The interlocking structure of the true rule of law. The Canadian jurisprudence gathered is not just a list of separate cases. It's a progression of principles that fit together like gears, each one turning the next until they form a closed system, a framework that forces government authority to rest on recognition of being and compliance with peremptory norms. Legitimacy of purpose. R.V. Big M Drug Mart Ltd. 1985. Principle. A law without a legitimate objective is void. Effect. Legitimacy is not presumed. It must be proven. Rule of law function. This sets the first bar. Laws cannot be tools of control or convenience. They must conform to higher principles of justice. 2. Accountability, symmetry. Zingre v. The Queen, 1981. Principle. Government actors must justify their conduct in law, just as citizens must. International customary law bars a state from invoking its own internal laws to avoid international obligations. Effect. The state cannot elevate itself above the law. It is bound to the same standard as the individual. Rule of law function. This removes the state's shield. Authority cannot be self-justifying. It must be grounded in universally binding law. 3. Recognition of being. Thomson Newspapers Ltd, Canada, 1990. Principle. Natural persons possess full legal capacity by operation of law alone, while artificial persons, corporations, agencies, governments, are creatures of statute. Effect. Human beings precede government. Recognition is inherent, not granted. Rule of law function. This fixes the foundation. The individual is primary, the state derivative. Recognition cannot be denied or conditioned by statute. 4. Charter Treaty Alignment. DeVito v. Canada, 2013. Principle. Canada's international human rights obligations guide the meaning of charter rights, which must be presumed to provide protection at least as great as international covenants. Effect. Domestic constitutional law cannot fall below international human rights standards. Rule of law function. This binds the Charter to the ICCPR and other instruments, making international obligations the floor of protection, not the ceiling. 5. Statute Treaty Alignment. Nemeth v. Canada, 2010. Principle. Statutes must, where possible, be interpreted consistently with Canada's international obligations. Effect. Legislation is subordinate to treaty norms. Domestic statutes cannot be read in isolation. Rule of law function. This harmonizes the whole system. International law runs through every statute as an interpretive baseline. The chain completed, Big M tells us a law without legitimate purpose is void. Zingre tells us government cannot excuse itself with internal law. It is accountable to international norms. Thomson tells us who the law recognizes: natural persons, not creatures of statute. DeVito ensures the Charter must be read in line with international human rights obligations. Nemeth ensures statutes themselves must also be read in line with international obligations. When these are read together, the structure is airtight. Authority is conditional. Big M. The state cannot escape international law. Zingre. Recognition belongs inherently to the human being. Thomson. The Charter must align with international rights. DeVito. Statutes must align with international obligations. Nemeth. What this means for Canada's authority. The illusion exposed. Canada's domestic authority rests only on de facto power when it conflicts with peremptory norms. The inversion corrected. The state does not grant recognition to the individual. Rather, the individual's recognition is the condition for lawful authority. The rule of law clarified. The true rule of law is not obedience to statutes, but obedience of statutes and governments to universal norms and the inherent dignity of the being. In sum, the true rule of law is not the supremacy of Parliament, nor the machinery of statutes. It is the interlocking framework that binds state power to legitimacy, accountability, recognition, and conformity with peremptory international law. Anything less is not lawful authority, but abandoned legitimacy.